Good morning. My name is Christy McCormick, and I'm the Vice Chair of the U.S. Election Assistance Commission. It is my honor this morning to introduce Acting Assistant Attorney General John Gore. John leads the Department of Justice's Civil Rights Division, which enforces federal anti-discrimination statutes and civil provisions of federal voting laws, including the Voting Rights Act, which of course we've been discussing at length today. Before joining the department in 2017, John was a partner in the Issues and Appeals practice at Jones Day in Washington, D.C. John's practice spanned all phases of appellate and trial litigation and a broad range of substantive areas including voting rights, administrative law, antitrust, and products liability. Prior to entering private practice, John clerked for the Honorable Bruce M. Celia on the United States Court of Appeals for the First Circuit. I'm happy to see several of my voting section colleagues from DOJ here today, past and present. We all have spent a lot of time working on language cases. Maybe we've even sued some of you who are here today. So we're eager to hear how the division is approaching its work now in the area of language assistance. So join me in welcoming John Gore.
Well, thank you, Vice Chair McCormick, for that wonderful introduction. And thank you to the EAC for inviting me to participate in this great event today. And I want to thank all of you. I want to thank all of you for your commitment to our vibrant democracy. If you stop to think about it, what we're talking about today is one of the foundational rights of our grand American experiment. It's the right to vote. It's the right to make one's voice heard at the ballot box. And federal law guarantees that right to all American citizens, regardless of which language they speak. So the work we're doing today is the work of promoting and enlarging and increasing our democracy for all Americans. I was honored to speak last year at the EAC conference in San Antonio. I said then and there that our goal at the Department of Justice is to usher in a new era of federal and state collaboration and cooperation in our election administration. Our vision is to work with state and local jurisdictions all across the country to make our elections more free, more fair, more open, more equal, and more accessible to all Americans. And we're pursuing that vision in the important and crucial area of language access. The Civil Rights Division, as Vice Chair McCormick said, is charged with enforcing the civil provisions of the federal voting laws. And that includes 3 provisions that relate to language. The first is Section 203 of the Voting Rights Act, which requires jurisdictions to conduct elections in languages other than English where they have a sufficiently large concentration of language minority voters. The second is Section 208, which allows voters with a disability or an inability to read or write to get assistance at the polling place, subject to certain exceptions. And the third is Section 4E of the Voting Rights Act, which protects the voting rights of Spanish-speaking voters from Puerto Rico. The Voting Rights Act charges the Census Bureau with the responsibility to make coverage determinations under Section 203. The Census Bureau makes those determinations every 5 years using data from the American Community Survey. The last round of determinations was completed in December 2016, and as we just heard, the Census Bureau is planning on the next rounds around the same time of year in 2021. As with past determinations after the 2016 round, the Civil Rights Division wrote to cover jurisdictions, informing them of the coverage determination and their responsibilities under Section 203. As part of that outreach, we pointed jurisdictions to our language access guidelines, which are published at 28 CFR Part 55, and they contain practical guidance and considerations for crafting a language program. Since that time, our outreach has continued all across the country to jurisdictions and local communities that are covered by the Census Bureau's determinations. Our outreach takes a number of forms. It can come in phone calls, it can come in in-person visits, or in monitoring on Election Day. A good part of the work we do in the Civil Rights Division and in the voting section on Election Day is geared towards gauging compliance with Section 203. In 2017 and 2018, the division conducted election monitoring at more than 24 jurisdictions all across the country, and we anticipate more monitoring through the fall. Our goal in all of this is to be helpful to the state and local jurisdictions and to be helpful to the local communities that need language access. So we've been all across the country for years and years now. We've seen a thing or two, so maybe we know a thing or two. And we have compiled a list of suggestions of best practices for jurisdictions and local communities that are crafting their language program. And I want to share a few of those with you today. First, we found that the jurisdictions with the best language program are the jurisdictions that do the best job of engaging the local communities covered by the coverage determination. Those communities have an obvious stake in the success of the language program, and they can bring a lot of resources and support to bear in making this program successful. They can identify bilingual poll workers. They can help translate written materials into the language. They can identify polling places where language assistance is most needed. And they can publicize the program throughout the community. Second, the jurisdictions that have the best language programs are the jurisdictions that are most effective and do the best job in targeting their resources to the polling places where language assistance is needed. The Department of Justice has long endorsed targeting as a method to comply with Section 203 and to meet language access requirements. And the whole idea of targeting is obvious. It's simply an efficient allocation of resources, whether they're poll workers or materials, to the polling places where language assistance is most needed. There's a lot of data out there that can help jurisdictions and local communities target their programs. We encourage jurisdictions to use census data from the decennial census and from the American Community Survey, and where appropriate, to use surname analysis so they can identify the polling places where language materials are needed. Our lawyers have a lot of experience in this area. They've done this for a lot of years, and we are more than happy to work with any jurisdiction and local community to help them craft the targeting of their language program. And third, the jurisdictions that do the best job in the language programs are those that train all of their poll workers, not just the bilingual ones, to understand the language program and the assistance and access that's available to all voters. And we also like to see jurisdictions advertising and publicizing the language program at the polling place. They can do that through posters or name tags that let people know what resources are available and who they should ask if they need assistance. So we understand there are a lot of challenges in complying with Section 203. We understand that language programs can be difficult, and sometimes the communities are, it takes work to engage with those communities and understand their needs. And in recent years, many jurisdictions have started adopting innovations in their election systems, which make voting a lot easier and more convenient for those of us who are voters, but can sometimes complicate the Section 203 picture. For example, many jurisdictions are expanding early voting and absentee voting, which means that jurisdictions have to make these resources available for a longer period of time. Many jurisdictions are switching to voting by mail or moving from traditional polling places and precincts to voting centers. And we understand and acknowledge that that can make the language program a little bit more difficult to administer. So our message today is a very simple one. We want to work with you. We're here to help. We are here to answer questions and provide assistance and to work together with jurisdictions and local communities to craft language programs and make our elections as open and as accessible as they can possibly be. Ultimately, that's up to the local jurisdictions and the needs in those communities. But we're here to help. So please don't hesitate to reach out to us, ask questions, and request assistance. And we'll do everything we can to help you in crafting your language program and in strengthening your local elections. So with that, I think I have a few more minutes if anyone has questions. Go ahead.
Thank you. Thanks for your presentation and your effort to improve the democracy. And I'm thinking that Department of Justice should have a lot of work to do, because you got to know people want to reach the Department of Justice who have something to comment or complain, probably usually be ignored. Just like regulations.gov or any website of government, maybe they are deleted or disregarded. So what especially in this voters voting and the democracy's sake, I think important is internet connections. Now we have internet supposedly invented by government, by now it's basically commercialized. And if we have this big corporation to monopolize all those internet communication, the general public have a disadvantage. And not only that, they will be obstructed, manipulated about their communication with any other people. So they make the democracy reverse, upside down. And second is the candidate information. The public government should be maintain some archive for candidate information, so you don't have to repeat every year, every month, every day you campaign, and basically with some kind of soundbite that really mean nothing. But it seems the system working that way, so there's no way to improve our system. So I just wonder if you can really, first is really resolve people's complaint and improve the internet communication. Before internet, we have a phone and a fax. That's the same thing. That's not only hurt the individual, but hurt their businesses because they obstruct everything. And then if people have complained, means their resources will be depleted too. So archive is very important. Currently, they have the vote.md.org. They maintain a good website. But it's some sort of, sometimes some people obstructed or manipulated their changes, so that makes it very difficult for the candidate information to really spread out. So if we can improve this direction, improve in archive and communication and people freedom to speak, and that would be good.
Well, thank you for your question, and I'm glad you raised the issue of the internet because we have posted a lot of materials on our website at justice.gov/CRT about our language access program. So we have information about prior cases. We have information about settlements that we've entered into with jurisdictions all across the country. We have contact information so that anyone who's got a question about a language program can reach out to us directly, let us know what their question is or their request for assistance is, and we are responsive to that, and we've been responsive all across the country. We hear from state and local officials. We hear from voters. We hear from voters who speak all kinds of languages, Spanish-speaking voters. We hear from Asian American voters, from Native American voters, even from Native Alaskan voters from time to time, all of whom are part of these coverage determinations that the Census Bureau makes. So we've made a very concerted effort to get the word out about our program, and I invite anybody who's got questions about it to visit our website and learn more about the work that we can do and the assistance we can offer in your jurisdiction.
All right, it's a comment from Mr. Mason. He would like us to think about deaf-blind voters, meaning both deaf-blind individuals, not blind and deaf separately, for various needs, and he expressed that while there are, it sounds like, forums to talk about disability needs, that it's hard to kind of know about those events. There was an instance where deaf-blind voters had to actually bring magnifying glasses to the polling place to look at the ballot. So certainly, as it relates to, I think, the Department of Justice, there's an opportunity, I think, for all of us to just be very thoughtful about the needs of various communities, and certainly DOJ is part of that enforcement effort to make sure that needs are not going unmet.
Absolutely. Thank you, Mr. Mason, for that comment. I completely agree. The Constitution and federal law protect the voting rights of all American citizens, including citizens with a disability. As I mentioned, Section 208 of the Voting Rights Act protects that right and allows individuals with a disability or an inability to read and write to bring someone with them to the polls to assist them in casting their ballot. We also have Title II of the Americans with Disabilities Act, which requires state and local governments to make all of their services, programs, and activities accessible to individuals with disabilities. And again, I would point you to our website and our prior work in that area. We've had an initiative for several years in the Department of Justice to improve the accessibility of polling places and of elections in many ways. We've gone out to polling places all across the country, even to improve physical accessibility, which is very, very important for citizens who want to cast their ballot on Election Day. We recently entered into a settlement in Arizona on that very issue, and as I said, we've had settlements and litigation all across the country. So we are aware of the issue. If you have more information about it, we want to hear that. We want to know what's going out in the field and what challenges individuals are facing, and we will bring our resources to bear to be of assistance.
Good morning. Jim Tucker. I'm pro bono voting rights counsel for the Native American Rights Fund, also a DOJ alum.
Wonderful.
I wanted to start off by thanking you, first of all, for the efforts of the department. You mentioned federal monitors. We've had federal observers in Alaska monitoring the improvements that have been made following the litigation we brought up in there. And I was wondering if you could possibly speak on efforts going forward that the department intends to undertake to increase the Section 3 coverage for federal observers, so that rather than using just federal monitors, you're actually able to use the folks at the Office of Personnel and Management to go out and monitor elections. Because again, it's very critical in terms of both enforcement and monitoring improvements for language assistance.
So I appreciate the question. I'm glad you raised it. I think, as you're aware, after Shelby County, it's been the position of the department that the provision that was struck down in Shelby County also affects our ability to send federal observers. And so since that decision, we have been using the federal monitoring program, and we're going to continue to use that program. We are heavily invested in it. We believe it's a strong and important program, both for language access purposes and for other purposes. As you're well aware, I would think, we've been to Alaska. The only thing that would make the trip to Alaska better for the division is if I got an invitation, because I'd love to go up to Alaska and observe conditions there. But we are aware of that issue, and we're certainly committed to continuing the election monitoring all across the country. Yes, sir.
The basic requirement of Section 3, to get Section 3 relief, is that a lawsuit be brought and you get a court order authorizing Section 3 relief. And in the last 10 years, there's been a huge drop-off in the department's enforcement of Section 203. And there hasn't been a single suit since 2012. And I'm wondering what the department's going to be doing, or what you're doing, to make sure that the department activates or reactivates the enforcement program.
Sure. Well, thank you for your question. What's most important is that jurisdictions actually comply with Section 203. And if we can help jurisdictions comply with Section 203 without having to file a lawsuit, everybody's better off. It's the most efficient means to get to compliance. It's most efficient for the jurisdiction, and it's most efficient for us. And we found that jurisdictions all across the country are willing to work with us. They're willing to take our assistance and take our suggestions and craft the language program that's going to work best for them in their jurisdiction. We've also had settlements that deal with Section 203 issues all across the country. So we will certainly bring enforcement actions where enforcement actions are warranted. That remains the commitment of the Department of Justice. That remains our charge from the Congress under Section 203. But we found a lot of success and a lot of willingness to work with us in jurisdictions all across the country.
We just heard earlier that in Clark County, Nevada, fewer than 6% of the census population of people who need election information in Tagalog are getting it from the county. And that seems to me to be a pretty poor result, and I wonder how long the department's going to tolerate that level of noncompliance.
Well, I'm not familiar with the particulars of the Clark County case or situation that you're mentioning. We have plenty of voting section lawyers here today who are taking notes, and I expect to hear more about it soon.
We have time for one more question over here.
Mr. Gore, you mentioned the monitors, how you sent some out recently, how you plan to do it again in the fall. Can you tell us a little bit more about what some of those problems were, or why you sent them to those places in the past and where some of those places are? And where do you plan to send them in the fall, and what are your concerns about those jurisdictions?
So that's a great question. What I can tell you is we've sent them all across the country, and we have been focusing on jurisdictions that are either newly covered or have newly covered languages under Section 203. And there have been a couple of places in various states throughout the South and really throughout the entire country where we want to go and observe the language program in its infancy and see how the jurisdiction is doing implementing a language program for the first time. That's really been our focus, but those aren't the only jurisdictions we've been to. There have been other jurisdictions we've gone to observe conditions generally in addition to the Section 203 language conditions. And so those determinations are made by our career staff who present that to me, and I approve those requests when they're made. But they have the best sense of where the monitoring is needed and where the support from DOJ is needed most in those jurisdictions. we don't. We've not gotten to that point with respect to the fall elections yet.
Well, thank you, John.
Thank you.
Appreciate you being here. Great information. So we have a break until 11 o'clock. We've got, I think, coffee. So please help yourselves and be back at 11. Thank you.